sort of targeting Obama's Clean Air Act. There were a number of Republican states that were opposed to his Clean Air Act, which really sort of restricted significantly the carbon emissions, right, that were allowed in our sort of power grid. So Obama's policy never even went into place, right? Because it was challenged almost immediately. Then President Trump came in and he completely threw it out and had his own policy that, as you can expect, was much looser when it came to carbon emissions. Now we have President President Biden in place, and the Trump policy is not valid. So, like, this whole case is about a bunch of policies that never were really enacted.
Exactly. And so we're holding the decision here in our hands right now. We're not lawyers, but Judge Vanessa Gilmore is here to break that down for us. She's a retired federal court judge. All right, Judge. So in the ruling, West Virginia versus the Environmental Protection Agency, what did the justices decide?
So you were right. There was a lot of back and forth between the policies that were enacted by different administrations. The Obama administration tried to expand the authority under the Clean Air Act by enacting the Clean Power Act to control greenhouse emissions. The Trump administration pulled it back. It's kind of gone back and forth. None of the policy has actually ever been in place. And today, the Supreme Court ruled that the EPA did not have the authority under the Clean Air Act to expand the ability to control greenhouse emissions. It was a 6-3 opinion decided largely along ideological lines, but the authority that the EPA was attempting to exercise is now not going to be able to take place. The Supreme Court says they do not have that authority under the Clean Air Act.
And so that means that the authority lies in the hands of Congress?
Yes, if Congress wants to revise or change the Clean Air Act to expand the control of greenhouse emissions through any of the previous policies that were trying to be enacted, then they will have to take up the responsibility of doing that. The EPA, as an administrative agency, does not have the ability to expand those controls themselves.
So, Judge, what does this mean? I mean, this 6-3 decision essentially says that the EPA's power to mandate carbon emissions should be tightened. It curbs their ability to do so. What does that mean going forward, not just for the fight for climate change, but for any government agency that is responsible for regulating and keeping us safe? In other words, we're talking about the FDA. And I mean, there's a whole slew of government organizations. I know when you say it's split along ideological lines, you essentially mean that conservatives generally favor a smaller government and liberals tend to favor a more expansive government.
The phrase that they use is major national significance. If the agencies sort of spill into an area that has major national significance, I presume that the decision is saying they shouldn't have that authority. That should be left in the hands of Congress. We're talking about talking about having a major influence on the economy, for example, changing the power grid, and that shouldn't be up to, you know, a federal agency with an administration that could change every 4 years.
Right, Emery, Vlad, great point, because the implications of this opinion go beyond the discussion of what the EPA can do with respect to the Clean Air Act. It would have implications with respect to other agencies, other regulatory agencies, and their ability through their rulemaking process to expand the function or purpose of particular acts of Congress beyond what Congress initially intended or envisioned when they passed that legislation. I think that it means that when you are looking at new legislation that is being proposed with respect to the regulation of clean energy or any other regulatory matter, you have to look specifically at the language of that statute to determine what the parameters are. And the agencies cannot go beyond the parameters that Congress decided when they enacted the legislation. That is an excellent point, because it goes beyond looking at what happens today with respect to this case and the EPA and the Clean Air Act.
So, Judge, you pointed this out. This fell along ideological lines, 6-3. I just wonder, with the American people and their faith in their institutions declining, some would say crumbling, and a decision that then kicks it back to the United States Congress, which is stuck in partisanship, right? Things have gotten way more political than they were 20 or 30 or 40 years ago, even going back to when the EPA was first created, obviously, right? Those seem like halcyon days in the 1970s, even though they were not. I just wonder if when people look at this decision and the Supreme Court is supposed to be apolitical and objective, that they don't see a sort of calcification of ideology in the Supreme Court, which is then kicked back to a body politic, the Congress, which is also extremely political.
I hesitated to say that the decision was 6-3 along ideological lines, because that seems to be the way that we describe a lot of the rulings that are coming out of the Supreme Court these days. But the truth is, as you stated, people have lost some sense of confidence in the Supreme Court. Recent polling has shown that the confidence of the United States, people of the United States, has dropped to an all-time low in the institution. But I think that it is also a sign of the times. The majority of the high-impact cases have been coming out along ideological lines, and I think that is just the sign of the times. That's just where we are today. I don't know what that portends for the future of the court. Obviously, there is a lot of rancor about the fact that justices are appointed for a lifetime, and the court that we have now is a very relatively young court, and so many of them will be on the court for many years to come. So I don't know that we can expect much change there. If the American people want change, I believe it has to be in the legislative branch of government.
And the thing about it is, the way things were right now, it would have been a bit of a workaround when it comes to congressional gridlock, right? Because it meant that the deference would go to the federal agency. If Congress is not specifically saying, here's what the EPA can do, then you defer to the agency. They got a bunch of experts there. They can make a better decision. And now, it goes back to Congress, where, as you point out, they get a lot of stuff done.
And Judge, the court has called this inquiry, the court called this inquiry a, quote, major questions doctrine. For those of us who are not lawyers, what does that mean?
Because the issue really goes back to whether or not it really has to do with the rulemaking issue, really has to do with the rulemaking authority, and whether or not that is a major issue that is a tremendous expansion of their traditional rulemaking authority. And in this instance, they determined that it was a major expansion of their rulemaking authority.
All right. We've got another ruling, and I don't know. I couldn't hear in my ears. Jessica
Levinson is standing by. She's reading up on it now, but it is the Remain in Mexico ruling. Judge, is the judge going to be hanging out with us as well? Okay, you're saying. Okay.
But she's been on the air with us and probably hasn't seen the ruling.
So we'll remind people about.
I'm going to have to get a chance to see that.
So we'll just remind people about what this case is all about. It has to do with the Trump-era Remain in Mexico policy, which stipulated that people who entered this country, undocumented immigrants, would then have to return to Mexico and wait, if they're seeking asylum, and wait for their asylum case. Right. So when President Biden took over, he decided to scrap that.
Right.
Then several states, including Texas took him to court over it because they wanted it reinstated. A lower court determined that the administration had two options, that you either detain an asylum seeker or you send them back.
Right.
And this is my casual talk now, because I'm not an attorney. Because it was determined that the federal government did not have the capacity to detain, and we did many stories on asylum seekers and the way they were being held, then they had to be sent back. And so sort of by default, Remain in Mexico was reinstituted, even though it was something that the Biden administration did not want.
Right. So joining us now to talk about that is CBS News legal contributor Jessica Levinson. She's joining us now to break this down. So in the case of Biden et al. Versus Texas et al., Jessica, what did the Supreme Court find?
The bottom line here is that the Biden administration is within its discretion to end this policy. It's a fairly complicated case dealing with a lot of technical parts of immigration law. Obviously, as I just heard you talking about, with really significant, very very real impacts for people and their lives and these asylum seekers and whether or not they have to stay in Mexico while they're seeking asylum during their court proceedings. The bottom line here is that the court got to the merits, and the court found that, in fact, the executive, in this case, President Biden, does have the power to say, we're ending this policy. They looked at a number of different provisions of the immigration law, eventually finding that the Biden administration was not required, didn't have a must detain, but in fact, instead had a may detain. And that's the bottom line of this opinion.
And so it's interesting that Judge Kavanaugh ruled with the liberal justices, Jessica. What do you make of that? And so did Justice Roberts, I'm being told.
It is. I will say that unlike the other cases, Vlad, that you and I and Anne Marie have talked about, where they're bigger constitutional questions about abortion, about religion, which in my view maybe more deeply affect your ideology. This is really more of a case, again, in my view, about statutory interpretation. And so, yes, as I said, it has very deep consequences for people's lives. But what Roberts knows, what Kavanaugh knows, what all the justices know here is that this is not just a ruling of, do we remain in Mexico? In fact, I think that really should be furthest from what we're thinking about. This should be a ruling based on, what does the federal immigration statute actually say here? And again, we're talking about, not does President Biden have the power to end, but does whoever's in the Oval Office have the power to end a policy that looks like this one in this immigration rubric? So again, when it comes to abortion, yes, it's going to fall on ideological lines. When it comes to religion, when it comes to the Second Amendment, but when it comes to statutory interpretation, even when it's a big case and it merits all of us talking about it, that's not always ideological lines. We can think back a few terms to when Justice Gorsuch came out with an opinion, again, statutory interpretation, not constitutional law, where he said that members of the LGBTQ community were covered under a federal discrimination law. That wasn't about your views of religion. That wasn't about your views of the LGBTQ community. That was about your views of, what does the statute say? That's today.
Judge Gilmore, I know that you got a chance to sort of peruse the decision. At the core of this, is it about an incoming administration's ability to conduct their own foreign affairs without being hampered by whatever the previous administration had done?
Ultimately, yes, that is exactly, as Jessica indicated, it really is about the ability and authority of this administration to look at the regulation of immigration into this country and make their own analysis of what should happen under that regulation. I've dealt with immigration issues here in Texas for decades, and this is something that the courts here have watched very, very closely.
And what's your take on what you've managed to sort of read so far in terms of the decision?
Well, it really does just deal with what the president's authority is to either pull back or maintain this remain in Mexico policy. The policy itself is one that has proponents and opponents on both sides of the issue. On the one side, the USCIS probably prefers that people be vetted and remain while they are in Mexico, because it gives them an opportunity to make sure that people really have the authority or should be allowed to come into the United States. But on the other side, it also results in situations where people are placed in danger or left in danger when they remain in Mexico. There have been many instances of people being abused and raped, and it also increases people's likelihood of taking risk like they did this past week, coming into the United States via the tractor trailer and risking death. 53 people have already died as a result of taking that risk to come into the country. I handled the second worst case of that nature that was a very, very similar case where 19 people died in a tractor trailer coming out of Mexico, coming that exact same route, trying to get to the United States, and took a risk that ended up resulting in the loss of their lives, and tried that case relating to that situation.
So let's mention that Justice Amy Coney Barrett wrote dissent for the case, and of course that included Justice Thomas's, Alito, and Gorsuch. They joined the dissent, except for the first sentence, which reads, "I agree with the court's analysis of the merits, but not with its decision to reach them." Jessica, what does that mean?
So it basically means that, and I'm sorry I have not had a chance to fully look at the dissent yet, but that sentence indicates that I wouldn't have gone on to the big question. I would have said that there's a reason that we shouldn't even be hearing this case or deciding the merits. And based on my knowledge of the background of the case, I suspect that what this really is that she thought it wasn't ripe for review, that she thought that this wasn't the moment that the court should be actually looking at the case. Again, I'd love to have the benefit of looking at the dissent, but she's saying once you get there, I agree with what you're doing, but I wouldn't have gotten there in the first place, which is code for there's a procedural reason why I think we as judges and justices shouldn't be here yet.
So this is sort of wrapping up a very historic time for the Supreme Court.
Yeah.
And we have an outgoing justice and an incoming justice, the first African-American female justice. And so before
that's happening at like noon today.
Before we let you go, I just want to kind of get both of your feelings on this. Judge Gilmore, I will go to you to start with. Being a former judge, an African-American woman, what does this mean?
Well, I sat through the hearings of Justice Jackson this spring, back in March, and it was an overwhelming feeling. I realized that I was sitting in that exact same place just 28 years ago going through my own confirmation hearing. So the emotional feeling that I had sitting there was one of such pride and respect for her. And I hope that when she is sworn in today, that all of us will be able to share the same sense of pride, not just in the court, not just in this particular justice, but in this country for coming so far to appoint the first African-American woman to the United States Supreme Court. It's a very proud and happy day for me.
Did you think, Judge, I know that what was interesting to me about this particular search for a new Associate Justice was that there were even conservatives who had put forth other black female justices. I know, for example, Senator Lindsey Graham seemingly appeared to endorse Michelle Childs, Michelle Childs. And I just thought to myself, I mean, so the president, of course, could choose whoever he wants, but the fact that there were multiple options for both a liberal or a Democratic president and for conservatives, what does that say to you? Or, I mean, just sort of what is that broader message about?
I think the broader message is that the bench is very deep in terms of qualified African-American female jurists to be considered for this opportunity. It's not a situation where they haven't been qualified or before. It's just that the opportunity has not been previously provided. And I think that this is a reflection of the willingness and ability of the Senate in this instance to recognize somebody for their qualifications, for their background, for everything that they can bring to this position, and to allow that opportunity to finally be fulfilled.
And I know they probably want us to wrap up, but I feel like
this is an
actually
important term for the Supreme Court.
Which we haven't gotten to, because I feel like, the two cases we talked about today, and of course Roe v. Wade, we're going to be feeling the ripple effects, right, of these decisions for many, many, many years to come. And so I'll ping pong back and forth, and I'll go to Jessica, and just, can you talk to us about some of the decisions that we've seen this term and how transformative they could be in terms of how we live our lives?
Extremely. So if we look at this term, it's the first full term with Justice Amy Coney Barrett on it. It's the first full term where we have the solid 6-3 conservative majority court, and the first full term where the conservative majority no longer needs the Chief Justice. And I think we really felt that. Even in decisions that were 6-3, the Chief Justice couldn't pull back. He couldn't get to a narrower place, even if he wanted to. And so what do we see? Obviously, when we talk about this term, we're all going to start by talking about overturning Roe v. Wade. But we also need to talk about those other cases. We have a shift in how we interpret at least the Second Amendment. I just read last night, when it comes to Los Angeles, I think we had about 1,000 concealed carry permits as of last year. Estimates are we could have 50,000 very quickly as a result of that decision. Those are really big changes. When it comes to religion, the court, I think, has said very clearly, we're very concerned about any laws that look like they're discriminating against religion, but we're not as concerned about any laws that look like the government is supporting or entangled with religion. That will have real effects for people. We're going to see next term. We already know what's on tap. We're going to talk about affirmative action, voting rights, and we're talking more about the religious freedom, freedom from discrimination. This is Judge Jackson becoming Justice Jackson absolutely will make a difference. But when it comes to some of these big decisions, the bottom line could still be the same, 6-3. This is going to be a very conservative court for a long time. And I think we've seen very big energy for them to kind of seize the mantle that they've been waiting for so long and go with it.
Judge Gilmore, we could hear you sort of...
Yeah, nodding along.
Yeah, agreeing.
Yes, I think Jessica is absolutely right. If Amy Coney Barrett stays on the court as long as Ruth Bader Ginsburg did, she'll be on until 2059. And so there is a lot of runway ahead in terms of this court and the makeup of this court. Justice Jackson will make a difference in terms of her ability to have some input on issues, but ideologically it is not going to change the bent of the court in any way. It is still going to be solidly 6-3 conservative. That's been a long time coming. Nixon appointed 4, Reagan appointed 3 justices, and Trump appointed 3. This has been a long game. And so the ideological makeup of the court at this point in time will have an impact on cases that are expected to come before the court in the next term, as Jessica already pointed out.
And Judge, but Judge and Jessica, there's also now talk.
That sounds like a great podcast, doesn't it?
It
Judge
really
and
does.
Jessica.
Judge and Jessica. You guys should talk about that. But there are some who are calling for the president, along with the Congress, in which, of course, the Congress is controlled by the president's party, to, and this is a word you're hearing a lot, codify. You're hearing a lot of people say codify, for example, the protection of women, the rules for Roe versus Wade, for marriage equality, and yet someone pointed out recently that the Voting Rights Act has been codified historically, and yet the Supreme Court was still able to gut it.
It has been chipped away.
It has been chipped away, and you're talking about affirmative action next term. So, Judge, first to you. I mean, when we talk about codify and we ask the president or we ask and I don't mean we, me and Anne Marie, I mean the people are asking in the president's party are asking him to enshrine these protections. What does that mean? And when the Supreme Court is able to chip away at laws that have been codified, what does that mean?
Well, if it's codified in the United States by the United States Congress, that means that all 50 states would be under the same law. That we wouldn't have 50 different sets of laws that apply to a particular issue, for instance, reproductive rights. But it does not mean that the Supreme Court can't go back and look at that law and evaluation of that law, because that happens all of the time. There are statutes that are constantly brought before the Supreme Court for interpretation. And so any law that might be passed would obviously be subject to interpretation by the Supreme Court in a particular case if some constitutional challenge was raised to that statute. So
it doesn't mean then, Jessica, that the reason I ask is because you're hearing a lot of people talk about that as if it's some magic wand that the president and the Congress can wave, and all of a sudden, boom, we're back to where we were before the Supreme Court decision. And people are attacking the president and his party for not doing it earlier. But what the judge is suggesting is that it doesn't really matter. I mean, it would matter, I guess, until somebody challenged it.
Well, of course, the judge is right. We'll talk about this more on our podcast this week on this week's episode. But I just talked to my students about this because I'm teaching constitutional law over the summer, and we came to class right after the Dobbs decision, and they obviously had questions. And the answer, of course, is that it's the Constitution that's the supreme law of the land, and so any piece of legislation, any federal statute has to comply with the Constitution. And so, of course, exactly as the judge says, all of these pieces of legislation are open to being challenged. When we talk about codifying Roe, that's not the same. It doesn't have the same strength as saying that a woman's right to obtain an abortion is protected under the Constitution. Congress can repeal legislation, and the court, of course, can reverse the legislation, can say that there's parts of the legislation that are problematic. I think there is a chance that this court looks at legislation that tries to, quote unquote, codify Roe and ask Congress whether or not they really have the power to do so. Now, I'm not saying that's exactly what the court will do, absolutely, but let's not assume that this court will say, oh, absolutely, Congress has the power. Now, of course, we're having this conversation, but the truth is Congress has known for so long that this was going to happen. Congress did nothing over and over and over again. And that's why we're left with, frankly, far less ideal, if you want women to be able to obtain abortion, far less ideal options where people are asking the president, can you do something by executive order? If we're talking about, the order of what type of protection you want for a right, you want it in the Constitution, then you want it in legislation, and then maybe you want it in an executive order. But President Biden doesn't have the power to legislate on his own. So we're going broad, narrow, even narrower. And I think that's what we're going to see going forward when it comes to the right to obtain an abortion. We've all had a conversation about what the next big legal battles are for abortion, so I won't rehash those here. But reproductive rights are coming back to the Supreme Court. This was not their last say.
Judge Gilmore, Professor Levinson, I look forward to your inaugural show, but thank you for joining us right now. Thank you.
Thank you.
We'll be right back.
An original documentary from CBS reports.
It's gonna be big!
The metaverse, the virtual world that's become a cryptocurrency casino.
It's like buying property on Mars.
Do they get an actual picture of this? No, it's a digital copy. Why would they pay for that?
Making millionaires almost overnight.
We made more than $1 million in crypto last year.
I have no idea how much money I have made over the past year. That's like, wow.
Big rewards.
There's gold in them, there hills, as they say.
Bigger risks.
The market's down, but it's gonna bounce back. It's crypto.
Is it a gold rush or fool's gold?
It's our metaverse, our story. Peace out, y'all.
An original documentary from CBS Reports. Stream now.
I'm Nora O'Donnell in our nation's capital. We're here